Good afternoon, everyone. My name is Danish Khan, and I'll be doing question 8 of the tutorial questions. And let's have a look at the question itself. A registered proprietor of an alienated land has exclusive but not absolute rights over his land under the National Land Code. So, what this question is saying is that as someone who has possession over a land, you have your own rights, but those rights have their own sets of limitation. So you're not free to do whatever you want with your own land despite your possession. And we'll have a look at how much truth there is in that statement. So for the introduction, the dimensions of ownership were famously described in the case of Corbett and Hill in the year of 1870, when Sir William James is cited to have said,
Cuius est solum ilius estus queerque lumes ad inferos.
which roughly translates to the rights of a landowner extend upwards to the heavens and also downward towards the center of the earth. So moving on, very quickly, under the common law, these are the three rights which are given to a landowner. The first one is the right to airspace, right to underground land, and also the right to support. And now, from this statement from the National Land Code, you can see that you don't actually have to be the owner of a land to enjoy the rights of an owner. You just have to have a lawful possession of the land. For example, by way of lease or by temporary occupation and etc. To answer the question at hand, we shall look at section 44 clause 1 of the National Land Code. And this is what section 44 clause 1 says. Well, to summarize everything that section 44 clause 1 says, we can have a look at this slide over here. So basically, all the natural rights stated in the common law, which were mentioned earlier, are also incorporated in our National Land Code. And the rights are as follow. Number one, the rights to the column of airspace above the surface of the land. Next, the land below that surface. And finally, the right to the support of the land. But we have to keep in mind that these rights are not absolute, as they are exclusive against a third party. And I'll clarify more about the third party in the coming slides.
Now, in regards to the rights of airspace, we can refer to the case of Karupanan and Balakrishnan. The case went like this. A 4-story hotel stood on lot number 26 with its windows sticking out into the airspace of lot number 25. Later, the owner of lot number 25 wanted to build a hotel and demanded for the windows to be removed. However, the owner of lot number 26 refused to remove the windows. The court then held that the law has clearly stated the rights of an individual over his own land, and therefore the owner of lot number 26 had no right to encroach into the airspace of lot number 25. Although we are given the rights to airspace, we must keep in mind that this right is not absolute, as there are considerations in regards to its limitation which must be subjected to. Firstly, the provision in the National Land Code section 44 clause 1a, which reads, the exclusive use and enjoyment of the column of airspace above the surface of the land and the land below that surface And okay, so this is what we have to pay attention to, as is reasonably necessary to the lawful use and enjoyment of the land. So the very last phrase is what matters the most. That's where we get the limitations from. This means that the rights of an owner in the airspace above his land is only limited to such a height that is deemed necessary for the ordinary use of his land. We do not own any right beyond that reasonable height. And also from this provision, it is safe to say that we own the airspace above our land, but only to an extent. There is a limit to it. Okay? So that's the first form of limitation. Moving on, the rights to airspace is also subjected to other written laws in Malaysia. And what we have over here is Section 19 Clause 1 of the Malaysia Civil Aviation Act 1969 that provides no action is considered as trespass or nuisance by reason of an aircraft flying over a property. And this was fairly illustrated in the English case of Burstein of Leigh and Skyview and General Limited. In this case, the defendant flew over the plaintiff's land to take an aerial photograph of the plaintiff's house. And the plaintiff then claimed that by entering the airspace above his property to take the photographs, the defendants were guilty of trespass. However, the court did not agree on this, and with reference to the UK Civil Aviation Act, the court decided that the defendant was not guilty because a plane flying like for hundreds of meters above the land to take pictures cannot be constituted as a trespass to land, and therefore there was no interference caused to the property of the plaintiff. Next, in regards to the rights below surface, Section 45 Clause 1A stated that the owner of a land has the right to utilize any rock materials from the land within the boundaries. However, there are limitations for the usage of all the rocks and also forest materials, which is stated in the very next section, which is Section 45 Clause 2. And the limitations are as follows. Firstly, all the rock materials and forest products belong to the state authority. Okay, that's number one. Number two, the owner of the land is only allowed to use the rock materials and also forest products within the alienated area only. And finally, they are not allowed to extract any metal or mineral from the land. Okay, so if you are thinking of extracting any metal or mineral, you would be required to obtain a permission. And so to summarize Section 45 Clause 2, it can be said that the owner can use the rock and also forest materials, but they are not allowed to take it as their own, despite having possession over the land which the rock materials were found on or in, because the ownership of those materials remains the property of the state authority, and it will always be that way. Now, with regards to the removing of rock materials from the land, you would be required to obtain a permit or license for that purpose. So although you are the owner of the land, you still cannot move any rock materials under or on the land without the permission from the state authority. So I hope it makes sense as how this is a limitation to your exercise of rights over your own land. Because you own that land, it's your land, but if you are about to remove anything from it, you would still be required to have a permission from the state authority. Hope that makes sense. Up next is the right of support. So right of support essentially means the right of a landowner to have his buildings supported by his neighbor's house or other structures. But to claim for this right of support, there are criteria to be met. And firstly, the first criteria is that the land at the lower level must support the land above it. That's number one. Number two, the land must be adjoining to each other, but it must be of distinct ownership. Next, in order to be entitled to the right of support, the land must be in its natural state. And finally, no additional support is to be given, so the owner cannot expect any additional support from the adjacent owner if his land is proven to be in a weakened state. Now, you see, these four conditions mean that not every single landowner is entitled to the right of support, because you have this set of criteria to meet before you'll be able to claim for the right of support. And therefore, if you fail any one of these criteria, well, then it's too bad for you. You'll be deprived of your right of support. With that being said, let's have a quick recap of the discussion. Firstly, in regards to airspace, yes, you have rights over the airspace above your land, but it is only up to a certain reasonable height. Okay, that's for airspace. Second, in terms of the usage of the lands underneath, the materials underneath your land, you are allowed to use the rock materials and also forest products, but it still remains as the property of the state authority. You are never the owner of those materials under your land. And finally, there are conditions to fulfill before you can claim for the right of support. So, to conclude, the landowner has special rights over the land, but those rights given comes with certain limitations, and therefore it is true that a registered proprietor of an alienated land has exclusive but not absolute rights over his land under the National Land Code. And that sums up my presentation. I hope that I managed to answer the question. If you have any further question, do let me know. Thank you.